Is it possible for a governor of a state to dismiss a state minister? Is what the question that is going to be answered in our today's discussion. Earlier this year, Kerala's governor Arif Muhammad Khan threatened to sack ministers who, according to him, lowered the dignity of his office. And recently, on 29 June 2023, R.N. Ravi, governor of Tamil Nadu, first sacked an arrested minister V. Senthil Balaji from the Council of Ministers before rescinding the decision a few hours later. However, Indian history does not record any instance in which a governor unilaterally removed a minister. This is where our discussion today will focus on 1. A governor's role in parliamentary system, relevant articles, appointments, etc. 2. Is it possible for a governor to remove a minister, a list of legal provisions, important judgments, etc. 3. Recommendations made by various commissions. Okay, now let us see, first and foremost, in parliamentary systems, governors play a number of roles. Articles 153 to 161 of the Constitution describe the position, role, powers, and conditions of office of the governor. Governors are the state's chief executive officers, while governors do not form part of real executive, titular or constitutional head like president. He is an executive head for the namesake. With some exceptions, he acts on the advice of the Council of Ministers as the head of the state's executive power. In turn, the state legislature is responsible for the Council of Ministers. Having been appointed by the president, the governor serves as a vital link between the union and the states. Of course, chief ministers and council of ministers are appointed by the governor. Now, let's move to the next point. That is, can a governor remove a minister? According to Article 164(1), ministers shall hold office during the pleasure of the governor. A governor, however, cannot remove a minister in his own capacity without the consent of the chief minister or after consulting with him. It will result in a parallel governance if a governor removes a minister in his own capacity without consulting the chief minister. Governors can only remove ministers when the chief ministers permits it. Among the most important judgments regarding the appointment, removal of the Council of Ministers are the case of Shamsher Singh versus the state of Punjab 1974. Except in a few well-known exceptional circumstances, the president and governor shall exercise their constitutional powers only on the advice of their ministers. Furthermore, the court stated that even if the prime minister or the chief minister loses majority in the house, or if the government loses majority but refuses to resign, as well as the dissolution of the house where an appeal to the country is necessary, even then presidents and governors should stay out of politics and rely on their prime minister at the central level and the chief minister at the state level to make the right decision. In case of Nebam Rebia versus Deputy Speaker and others 2016, observations by Dr. B.R. Ambedkar were cited by the Supreme Court. The governor has no function that he can discharge on his own under the Constitution. Despite his lack of functions, he does have certain duties to perform, and the House should keep the distinction in mind. This is what Dr. Ambedkar said with reference to the role of the governors in India. However, the following recommendations have been made by various commissions on governors. In 1983, Sarkaria Commission was set up to examine the relationship between the center and states. As a part of the process of appointing someone to the governorship, it has proposed a number of additional criteria. Prior to selection of governors, the PM should consult with the state chief minister and vice president and speaker of the Lok Sabha. In 2000, the National Constitutional Review Commission was established to review the constitution's workings. A significant change in the selection of governors was recommended by the commission. According to the commission, the president should appoint the governor of state after consulting with the chief minister. And in 2007, Punchi Commission stated that the governor should be chosen by a committee consisting of the prime minister, the home minister, the vice president, the speaker, and the relevant chief minister. The report also recommended deleting the doctrine of pleasure from the constitution, but backed the right of the governor to sanction prosecutions against the advice of the state government. Additionally, it called for impeachment of the governor by the state legislature in case the governors exceed their constitutional powers. So, if we take the whole legal discussion into consideration, governor may sanction for the prosecution of a minister irrespective of any recommendation coming from the chief minister or council of ministers. But a governor cannot straightaway sack a minister without the permission of the chief minister or the recommendation of the chief minister. In such scenarios, the Punchi Commission says that impeachment of the governor be allowed by the state legislature. Hope the information is useful to you all. Thank you very much.